Yeah.
Yes,
You
we can
can?
hear you.
Oh, okay, because
Yeah.
my message says we're muted. Okay,
Okay.
all right. I guess that's just gonna stay on there.
All right, we are on the record. Good morning, everyone. We are here today for the third day of hearing in the case of Ostrowski versus State of Wisconsin Department of Corrections, CR 2023-00758. Today's date is April 3rd, 2026. My name is Peter Reinhardt. I am the administrative law judge who has been assigned to hear and decide this case. This hearing is being conducted using the Microsoft Teams video conference software. The audio and video of the hearing will be the official record of this hearing. The complainant, Cindy Ostrowski, now known as Cindy Irwin, appears in person and by her representative, Deborah Keither. The respondent appears by attorney Michelle Zacard. Also present is paralegal Stephen Ross. Ms. Ostrowski, who will your next witness be?
Cheryl Eplett.
Okay, and she should be joining us momentarily. I told her to get back in at 10 after 9. While we're waiting, I think we can make productive use of this time. I can give you my final, not my final, but my notes about what exhibits are in and are not in. If the parties want that, I think I will provide it regardless. So with respect to the complainant's exhibits, here's what I have into evidence from the prior 2 days of hearing. I have C3, C7, although the second page of C7 was missing and needs to be provided. C9, C41, as to the second part, was admitted, the email between LeBron and Tomey. C48, C39, and C72. Then with respect to the respondent, I have R1 through R6, R15, R16, R22, the first page, R29, and R30. Exhibits that I had as offered and not received are C12, C13, C31, C60 I had a question mark about. C60 was referenced. C60 through C64 were referenced but not received. C74 and then respondents 20. And then R8 was referenced but not offered. So that is my list. We can take up any disagreements with my list at the end of the hearing. Also, while we're waiting, because we might have 2 more minutes, why don't we just have a discussion about what the parties want to do with respect to post-hearing submissions. Ms. Ostrowski, Ms. Keither, we had talked about potentially doing post-hearing briefs. Do you have a position on what you prefer?
Well, I don't know if, not really. We're open and flexible, but maybe we could mimic what we are doing in the other forum with Stephanie ALJ Brown, which is we not simultaneous briefs, but we would write a closing. The respondent would respond, and then we can respond to that. I don't know what that's called, but that's an idea. I don't know if Attorney Zacard has any preference.
Attorney Zacard, we don't have to necessarily resolve it right now, but your thoughts about your preference with respect to post-hearing submissions?
I think that's fine.
Okay. And did Administrative Law Judge Brown place any page limits on post-hearing submissions?
She did not.
Okay. Well, I will tell you, and we can again circle back. I'm always in favor of page limits. I think when page limits are imposed, it causes people to be more efficient and choose which arguments are really arguments they want to pursue. So I'll just leave it at that, and we can make that decision at the end of the hearing. She should be in momentarily now.
Well, I guess well, we can do the dates as well later.
All right, here she is. Ms. Eplett, please take yourself off of mute if you can, and also put yourself on video if you are able. And I don't think you're on video. There you go. Thank you. And can you hear me okay, Ms. Eplett?
Yes.
Okay, so let me just identify who's here. So we have for the complainant, we have Ms. Keither and Ms. Ostrowski. For the respondent, we have attorney Zacard and also paralegal Ross. And let me, before I swear you in, let me tell you what is going to happen. So I will momentarily swear you in, then I will just ask you to state your first and last name, spell it. Then I have two preliminary questions I ask of all witnesses because this hearing is virtual or remote, and that is just that you confirm that, in fact, you are in a room alone testifying and that you don't have any materials or documents on your desk or on your screen that you're looking at other than those documents that might be shared with you on the screen. After that, then the complainant's team one of the two will be asking you questions, followed by attorney Zacard. I may have a question or two. Also, during the course of your testimony, it's probable that one or both parties will ask you to look at documents. If they do, I will share them on the screen. You are certainly entitled to ask me to enlarge the document or scroll up or down to the extent you need to see the document to answer the question. It is entirely fair for you to see what parts of the document you need to answer the question. I am not sure, Ms. Epplett, how long your testimony will take today. I am fairly certain we will be done before noon, hopefully much sooner than that. So with that, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Would you please state your first and last name for the record and spell your first and last name for the record?
Cheryl Epplett, Cheryl. Last name is Epplett.
Thank you. Can you confirm, Ms. Epplett, that you are in a room alone as you testify here today?
That is correct.
And can you also confirm that you don't have any written documents or materials pertaining to this case on your desk in the near vicinity or on your computer screen? And if you do, I just ask that you turn them over.
Okay. Yep. I have documents that I had been previously sent by the state, so I will just turn them over, and otherwise all I have with me is my phone.
Okay. Then I just want to get some background questions. Were you at some point employed by the state of Wisconsin Department of Corrections?
Yes.
And do you recall when you last worked for the state of Wisconsin Department of Corrections?
I retired August 3rd of 2024.
All right. And at the time you retired, what was your job title?
Warden.
And were you at a particular facility, Ms. Epplett?
Oshkosh Correctional.
And for how long were you the warden at Oshkosh Correctional?
3 years.
So from 21 through 24?
Correct.
Okay, thank you. So Ms. Keither and Ms. Ostrowski, who will be examining this witness?
I will.
Okay, please proceed with your examination.
Okay, thank you. Good morning, Ms. Epplett.
Good morning.
So I just wanted to get back to the documents that were sent to you. When were you first contacted by the respondent? Anybody from their legal office pertaining to this matter?
Well, I'm not exactly sure how to answer that, because when I was still working, when I was still employed at Oshkosh, there were dealings with the hearings, certain hearings, and that may have been WERC, and it may have been preliminary, having to respond preliminarily to the allegations. So it's hard for me to say exactly.
Ms. Epplett, I think, and I'm sorry to interrupt you, but I think what Ms. Keither is asking you is, when were you first contacted with respect to preparation for this hearing? Ms. Keither, is that the question you're really asking?
Yes, for this case.
For this proceeding. So in other
Yes.
words, you don't need to address any prior proceedings you were involved in. She's really talking about your testimony for this proceeding.
Okay, sure. So I want to say, let's see, we're in April sometime. I don't remember exactly. I want to say maybe in February. I could be off with that. I don't even remember when we were originally, when this first hearing took place. And then it was rescheduled for today. But I would say it was from the first time, from the hearing that was scheduled for the 2 days. It was probably maybe a couple, 2, 3 weeks prior to that.
Hold on. Okay, and how did you get contacted? Was it by phone, email?
It was email.
So you got an email, and you got an email to what email address did you get contacted by?
My personal email,
And what is that email address?
cheryl.epplett@gmail.com.
Did you ever get a phone call in preparation for this
Correct, I did.
proceeding? Yes, and so, and who talked to you on the phone?
That was Michelle Zacard and Stephen Ross.
Okay, and about how long was that phone call?
It was set for 30 minutes, I think. They're normally 30 minutes, and I think it was right about 30 minutes.
When you say normally, what do you mean they are normally 30 minutes?
Anytime that there's a witness, like a witness prep in preparation for a hearing, it's usually about 30 minutes.
Did you get a calendar invite?
I don't know. I don't think I got a calendar invite.
And when they called you on the phone, what phone number did they use?
My personal,
Do we
my
want
personal.
to?
Yeah, why do
Sorry.
you need her personal phone, Attorney Keither? I mean, Ms. Keither,
You
that is
can-
not information that you need to get.
Well, okay. Thank you. Did anybody from the respondents' legal team, we know the answer is yes, but I still have to ask the question, I guess, for the record. But, did they send you any documents in preparation for this hearing?
Yes.
And do you know what they sent you?
It's when I was first asked by the ALJ what was in front of me, it was those documents.
I haven't seen those documents. I'm the only person here who hasn't seen them. So you're gonna have to tell us what those are.
Okay, it's a stack. You want me to go through them?
Sure.
So the first one is Executive Directive number 2. A lot of it is policy procedure.
Okay, then you can go through those really fast. Go ahead.
Sure. Executive Directive 2, Directive 5, Directive 35, Directive 43, Executive Directive 50, Executive Directive 75, policy on disciplinary guidelines, Executive Directive 58, this is an email from Emil Tony, email from Stephen Ross.
What does the email from Stephen Ross say?
Oh, actually, Stephen Ross isn't, I don't know why this says, oh, because he probably printed it. I'm sorry. It is not from Stephen Ross. It's probably the person who printed it. It's
We're
from
gonna need
Tony.
these.
It's from
Okay.
Emil Tony. And yeah,
Maybe
Um,
just I'm sorry, is there a number on the top right corner of it, like R something?
Yep. So the
Could you-
one that I'm referencing that's from Emil Tony is R44.
Okay,
Okay. You can just read the numbers. If
Okay.
they have a number.
Yeah, so all of them did. I'm so sorry. Do you want me to go back and read the R number
You know
or
what?
just pick up where we left off?
Just pick up where we left off.
Okay, so I've got the one I was just referring to is R44. Then I have an R56. R57, R58, R59, R60, and that looks to be it.
Okay. So did you say you got these by email?
They came by mail,
Uh, Postal mail?
correct?
Okay. And, but in the emails that you received from Attorney Zacard, what was in the body of the emails?
I think it was just saying in preparation for hearings, for witness prep,
Did you bring those today?
bring,
You were supposed to bring any bodies of emails that you received, not just the attachments, but what was said from Attorney Zacard to you in the email.
oh, no, I didn't bring that today.
Why not?
Your Honor, I guess, we provided the emails to you to do the the in-camera review. Would it be helpful if Mr. Ross forwarded that information to Ms. Keither?
I think it would be perhaps a better way to proceed.
Okay,
Ms. Keither, while we're waiting, I will just say, as I stated in my decision, I have looked through the documents. There's really not anything that is going to be significant one way or another. You're entitled to take some time, but I'm not going to let you spend more than 10 minutes or 15 minutes talking about the documents she received. So that is your limit.
Thank you for that. I appreciate you putting that limit down, and this is well within our right. It was on the subpoena. So the subpoena stated that direction very, very clearly to the witness. And once again, I highlight that even though we knew this is a third-party witness, so by that description alone, to entertain what has transpired has been very prejudicial to us. And we still don't know what all of you are talking about, but thank you for that. And
Well, the other thing I'll
continue.
state, Ms. Keither, is you served a subpoena for the witness to appear today and produce certain documents. The normal process is the witness shows up with documents. So you weren't entitled to get those documents ahead of time. But again, I circle back.
Which is why I
we've
didn't
already-
ask for them.
Yeah,
She
so
doesn't
go
have
ahead.
them today, though.
Right.
they've been sent.
I just asked her, well, I can't look at that right now. I just asked her if she had the documents as it was written on the subpoena, and she did not.
I
So
think-
that is when Attorney Zacard interjected with her version of how we could resolve the issue, which again is not beneficial to us at this juncture. So let's proceed because I have a limited
okay.
amount of time. And from the ALJ, I only have a couple minutes to ask these questions, I guess. So I need to get back to them. Ms. Eplet, in any of the emails or phone conversations that you had with Attorney Zacard or any paraprofessional, secretary, anybody that was representing the respondent's legal team, did they tell you about a sequestration order?
If you're referring to not to discuss this with anyone, that, yes.
Okay, so they told you you couldn't discuss this with anyone in the body of the email?
But you know what? Now that I don't know for sure. And the reason that I'm saying that is I've also gotten emails from the DOJ regarding inmate lawsuits as well. And I can't remember if it was definitely in the DOJ, but I'm pretty sure it was the state of Wisconsin as well.
Okay, what I'm asking you is, well, here's a new question. How did you get the information to log in on day one of this hearing?
That was sent to me by either Michelle or Stephen Ross. I can't remember which.
And did they just forward it to you, or did they write something in the body of the email?
I think when it came to sending the link, it was just the link. I don't think that there was anything else in the body of the email.
So did she send a separate email telling you what this link was and what you should do with it?
Well, I think so. During the I mean, like, I was advised as to when the hearings were going to the days and the times of the hearings. And then initially, I think for the first hearing, I feel like I followed, it was just a follow-up. Is there, at me asking, is there a link to use? And then that was sent to me. Just like for today, the link was on the subpoena, but I reached out and asked if they could send the digital link, because it's just so much easier than having to type it in, and that was sent to me.
So you knew about the first 2 days of this matter, and you tried to log in on day one, correct?
Yes, yes.
Did you have a subpoena?
Objection relevant.
Sustained. Move on.
Well, there was a sequestration order, and the respondent would not produce witnesses. However, she did produce them for her own benefit, which was to have a sequestered witness, third-party witness, be preempted with all the paperwork, and also to listen in on the hearing prior to her testimony.
I really don't know what you're referring to. Are you asking let me just ask, Ms. Eplet, did you listen to the hearing at all? Either the first or
Nothing.
second day?
That was not my question.
Well, we're not
because
going to revisit what happened at the last
Did you
hearing.
log in to the hearing that day, and were you removed by the ALJ due to a sequestration order?
Objection relevant.
Sustained.
Witness tampering is irrelevance. Okay, we can move on and we'll take this up in another jurisdiction.
I'd like that last remark struck from the record.
Well, Attorney Zacard, I can't strike a comment by the attorney, but it is a comment that is not appropriate or helpful. So move on, please.
Right. Thank you. And they have been made by you as well, saying take this up someplace else. So I'm just following what you've said in the past. Okay, so ALJ Reinhardt already asked you some general questions about your employment with the DOC. Do you remember what years you worked with Ms. Ostrowski?
I was at Oshkosh from April of 21 to August of 24.
Right, but when did you work with Miss Ostrowski during that time frame?
Well, I never worked directly with her. I mean, I'm not sure I'm understanding your question. I mean, I had contact with her throughout those 3 years.
Okay, okay, but when did Miss Ostrowski get terminated?
That was April of 23.
Okay, so really from 2021 to April of 2023 is when you worked, or you were supervising, or you were the warden of Oshkosh. Were
Correct.
you the appointing authority for Miss Ostrowski's matters?
Yes.
So appointing authority is the decision maker, correct?
Well, that's to me, that
It's an
question,
easy question. Are you the appointing authority and are you the decision making in the termination?
Ms.
Uh,
Keither, let the witness answer the question. You just interrupted her. Ms. Keither, please continue your answer. I'm sorry, Ms. Eplet, please continue your answer.
so yes is the answer to that question. However, it is more complicated than that because wardens do not independently make decisions regarding any kind of discipline. We can make because there's different steps in the process for consultation. And there's when you talk with with HR and your ER specialists, they give guidance and advice regarding comparable cases. Um, so so there isn't the wardens don't make these decisions independently, and some would argue that we don't make the decision, we make the recommendation, and it goes up the chain for either approval or disapproval. But at the end of the day, there is a decision that I make based on all of the information that I have and the guidance that I've gotten.
Thank you. That's where we're trying to get here. So what was the comparable case that you used in Miss Ostrowski's performance and termination decisions?
I don't
objection.
Yes,
remember.
because
All right, there's
these
an
are
objection.
conduct.
Hold a sec. There's an objection. What's your objection, Attorney Zacard?
This is about the termination hadn't happened at the time this was filed.
The objection is sustained. We're not going to get into the termination.
But you were the appointing authority on that termination, correct?
Yes,
And a bunch of other people signed it, right?
correct.
So you're the decision maker.
Objection asked and answered.
Your objection is sustained. We're not, I just instructed you, we're not getting into the termination. For the record, there was an entirely separate proceeding and hearing on the termination. The termination is not part of this case. Move on to your next topic, please.
So when did you learn about this ERD complaint?
I feel like I learned about, to be honest with you, I have lost track exactly like what leg of the complaint we're dealing with right now. But I was still employed at Oshkosh when we, were made aware from ERD that there was complaints filed. And I don't know if that was prior to 2023.
And so you were also aware of other internal channels that were being exhausted by Miss Ostrowski concerning her complaints against the department. Is that true?
Objection. Sorry, didn't mean to interrupt. Objection vague.
Overruled. Please answer the question if you can.
So, I'm sorry. So when you say other, if I'm repeating it accurately, you said other internal processes?
Channels. Yeah, your mat, your art, your dart, your, all those things, the work, the WCER, were all those things going on prior to the ERD?
They, to me, they seem to kind of collide. So there was WERC was going on, there were ERD complaints filed, and it felt almost simultaneously, but I honestly can't remember dates sequentially. What WRC, if that was first, I think I want to say WERC hearings were probably first, and then the ERD complaints followed, but again, I don't have anything sequentially memorized.
And were these all while Miss Ostrowski was employed, or were they happening after she was terminated?
I believe both. It was when she was, and again, I'm just going from my memory from years ago, but I feel like some of them were going on when she was still employed. But then after the termination, I believe there was more ERD complaint.
Okay, so while she was employed, there were many things happening with the complaint process. Um, are you aware,
I'm sorry, was that a question?
no, or unless you want to say, is that true? And you can answer that.
Are you
There's not a
asking me?
question, there's not a question pending before you.
Oh, okay. So how did you find out about all these complaints?
Well, typically if, when I was still working, the complaints would come, I want to say that HR either would make me aware or they would come right from they would come from either, depending upon what it was, they would come from our personnel or like the ERD investigator would send things to, I believe it was HR first, and then HR would forward that on.
Would they ever forward, did you ever receive a complaint that was forwarded where Miss Ostrowski was complaining about a supervisor and that supervisor was on the email?
Section vague.
I can't remember.
What were Miss Ostrowski's complaints about that were forwarded to you? The ones that were forwarded to you that you were made aware of by HR or others, what were those complaints about?
So there was, from my recollection, there were complaints about supervisors interactions, supervisors, the tone that they were taking with people, what supervisors did or didn't do. It was supervisors, it was one other supervisor, it was a unit manager, it was that they were undermining Sergeant Ostrowski's, if there was a rule on the unit, and or a discipline that was imposed, that the unit manager was undermining that and allowing the inmate to violate whatever the rule was or whatever the discipline that was imposed. So there were concerns expressed about that particular supervisor. Last hearing, we talked about, there was a lieutenant who sent an email to staff, and so regarding a spilled soda in a refrigerator. So it was, again, it was kind of the complaint about the supervisor overstepping. Well, overstepping probably isn't the right way of saying it. the tone the supervisor took, the leap that the supervisor took. I'm trying to think. I think there was, oh no, that was a different, yeah. So, I mean, generally speaking, it was complaints, concerns about supervisors, how they were handling things, how they were processing things, addressing things or not addressing things.
Was there a complaint by Cindy Ostrowski about a male inmate masturbating openly in his cell?
Yes. So that, my recollection with that is there was a conduct report that was written for that instance. And
Are you looking at
I'm-
something? Oh,
no, I'm thinking because there was a situation where I believe it was the deputy warden had dismissed the conduct or deleted the conduct report. And I think that was the same case, but I could be getting that mixed up because there were two situations where there was a difference of opinion as to how a situation was handled with two different inmates. So, but
So-
go ahead.
Can you repeat for me, because I didn't get it all of it written down quickly enough. You said a deputy who dismissed the case?
I don't think that it was dismissed. I think that the conduct report that Sergeant Ostrowski wrote, in this case, I believe it was either dismissed or deleted. There was one instance where the conduct report was deleted, and I can't remember if that was where the inmate was got written a conduct report for masturbating in his cell, or if it was for another inmate who came out and he had on his thermals and his shower shoes. And I thought Sergeant Ostrowski had told him to go back to his room. And there was an issue with how that was handled in the conduct report for that as well.
Okay. Do conduct reports sometimes get sent back?
They can, yes.
So do they call that return for service?
To be honest with you, I'm not sure what it's called. That sounds accurate, but I don't know for sure.
So if I was a Department of Corrections worker and I made a mistake on my conduct report, could I ever fix that mistake? Is there a process to fix a typo or a box that's checked wrong?
I believe that there is. I believe supervisors, when they review the conduct reports, I wouldn't find it unusual that the supervisor sends it back for correction or review. The same with incident reports. They would go back, with the supervisor giving guidance on, okay, you need to answer who, what, why, where, when more succinctly, or something was missing. And my recollection is, I believe that could happen with a conduct report as well.
So if a conduct report was deleted in its entirety, are there only certain individuals who can completely delete a conduct report?
Yeah, yes. My impression and understanding was it was myself and the deputy warden.
Is deleting a conduct report a big deal because it impacts the inmate's, historical record of incarceration?
Can you repeat that?
So it's a big deal when a record gets deleted. Like, in other words, you can't just go around deleting them, but because this is a historical capture of what the inmates, history is while they're incarcerated.
I'm going to object. This question's compound, and part of
it
it, I
is.
don't think.
It's compound and argument. So it's sustained. You can certainly re-ask the question. But the way it's stated, it has several clauses in it. So is your question really if whether or not the deletion is a significant, well, I don't want to I don't want to state your question, so please try to rephrase it.
That is what I'm trying to get at.
Out of the
Our-
ordinary, perhaps, is it out of the ordinary to delete a conduct
Yeah.
report? That would be helpful to know.
Okay, is it atypical or out of the ordinary for a conduct report to be completely deleted?
So I would say that, it's not ordinary. But so from in the background, I couldn't tell you how many times a conduct report was deleted in any given year because most of the time I didn't delete conduct reports. That was usually the deputy warden. I can say that in the 3 years that I was warden at Oshkosh, I probably deleted 3 conduct reports. And the reason that I deleted them was, I can't remember exactly, but a lot, the one thing that comes to mind is the ones that I deleted were like duplicate, or something to that effect, but it doesn't happen very often, at least to my knowledge.
Yeah. Okay, thank you. And can you delete a conduct report without consulting with anybody?
You're talking about her as warden, correct?
As a warden, because I believe you said you just said you were able to delete reports, but it was rare. You did it maybe 3 times, and it was for something like a duplicate. If you were to delete a report, would you have to consult with somebody, and let them know you're deleting it?
No, usually what would happen is the security director when the deputy warden wasn't there, the security director would come to me and say, this is the situation. Can you please delete this conduct report? And that was it. I didn't consult with anyone.
And well, the security director, it was the security director. Who was the security director during Miss Ostrowski's employment?
Emil Tony.
Did he ever come to you about deleting a conduct report of Miss Ostrowski's?
Objection, not in evidence, like a foundation.
Overruled, and let me tell you why. She's asking, Ms. Keither is asking if it ever occurred, and if Mr. Tomey came to her and asked her to delete, she would know. So the objection is overruled. Go ahead and answer the question, please.
In all honesty, I could not tell you 100% what conduct reports I deleted, but I don't think I was the one who deleted any conduct reports written by Sergeant Ostrowski. Because I during some of the previous dispute about the conduct report being deleted, my recollection is that was Jim Zanin, Deputy Warden Zanin, who deleted that conduct report. I feel like the conduct reports that I have deleted, the small amount were like I said, like it was a duplicate, or it was, I don't know. I want to say that the conduct report became irrelevant because somebody else had written it or something to that effect. But I don't believe I was ever somebody who deleted something that Sergeant Ostrowski wrote.
Did you ever talk to Jim Zanin about Miss Ostrowski's conduct reports?
No, well, let me preface that. We never had any discussion about it until it became, until Sergeant Ostrowski brought it forward as to why did this happen. And then I remember having a conversation with Deputy Warden Zanin, and he had said, to my recollection, he had said that, I think he said he had reached out to Sergeant Ostrowski and there was no response, and certain amount of time had gone by, and then he deleted the conduct report. But that conversation was after the fact, and after when Sergeant Ostrowski brought that forward to say, why did this happen?
Do you think there's anything negative that can happen to a corrections officer when a conduct report is deleted?
Well, so correct me if I'm wrong, but the way that I'm interpreting your question is you're asking me if something could happen, if there's a negative impact. And so I think or is it detrimental to the officer? Does it undermine the officer or the sergeant? Sometimes when conduct reports either are deleted, although I think that's the lesser of the two, rather than them being dismissed, or during the hearing, there's a disposition that isn't it is a disappointment potentially to the officer or the sergeant. And so I think that probably if there's anything from my perspective, it would be the sergeant or officer feeling as though they were potentially undermined, or that they weren't taken seriously. And so, sometimes that can be the response when it's either, I can't even say so much about a deletion, but more my recollection is when something is dismissed or there's a disposition given that's where the sergeant or officer thought that there should be a heavier or weighted, more weighted disposition. So from my own experience, just being in the facilities and talking with people, it's the sense of, hey, I wasn't taken seriously. Somebody undermined me. The only thing I want to add to that is, I don't know if it's relevant or not, but I have to say that I completely understand when something has happened, an incident has happened, a sergeant or officer writes a conduct report, and there's, we have the 303, there's guidelines. Sometimes there's wider guidelines than others in the 303 for discipline. But over the years, we're taught that you write the conduct report, let it go to hearing. It's two separate steps, and don't ever look back to see what the disposition was. Now, I know that that's, we're trained that way, but that doesn't always happen. So anyways, that's probably more than you wanted to hear, but I do, like I said, I do understand that there is frustration at times when there's a disagreement between the hearing officer and the person who wrote the conduct report as to what the outcome should be.
Do you know if masturbation is a major or a minor offense in the conduct report?
Haven't looked at a 303 for quite a while, but I would have to say that's a major.
And like you said, if an inmate was doing that and it was dismissed or deleted, that could pose a challenge for the correctional officer who has to oversee that inmate, correct?
I guess it's plausible that it could pose a challenge, although I don't know what, in every circumstance and every situation, I don't know what the challenge necessarily would be, but it's plausible.
Do you think if the sergeant was a female and the individual that was masturbating was a male, would that pose a unique scenario?
Well, I don't know that it would be unique because we have so many females working in a male facility and inmates inappropriately masturbating in plain view, in plain sight. That's a constant problem in an institution. So I'm sorry. What would something about unique?
Well, that's okay. I'll ask a different question.
Okay.
So are there a lot of conduct reports about with major offenses with inmates masturbating?
Section.
Hold on a second. And one thing I didn't say, Ms. Eplet, on occasion, one or both attorneys, depending on who's doing the questioning, may object. If you hear an objection, I just need you to pause so I can hear what the basis of the objection is and make a ruling. Attorney Zacard, what is your objection? The question was, so are there a lot of conduct reports about with major offenses with inmates, and I think it was going to, I don't think Ms. Keith was able to finish it. I think with inmates masturbating, I think was the question. Was that going to be the completion of your question, Ms. Keither?
Yes, my question, go ahead, yes.
And so with that complete question out, Attorney Zacard, I'd like to hear your objection, and then I will issue a ruling.
Objection, speculation, vague.
I can reword it.
All right, why don't you do that?
Miss Applett, are in the database, Wix or whatever they called it at the time, the one that holds conduct reports, would there be a large number of major offenses for masturbation in the years that you worked at Oshkosh?
I don't know that I would say that there'd be a large amount. I honestly couldn't tell you the frequency. But yeah, that's hard to answer because
Well,
it's a
earlier,
Well, let her
sorry.
finish please finish your question before Ms. Keither goes on to the next. Did you finish your question, Ms. Eplet, or did you have something additional you wanted to add?
I just wanted to say it's hard for me to say, on any given year how many conduct reports were specifically written for masturbation, but I know that having a career, it is an ongoing issue throughout a correctional facility. And I don't know, when I say ongoing, I don't mean I can't put a number to that, but it's an ongoing issue.
And let me interject. Can you give us a range, perhaps? Because I don't know what a lot means. It can mean different things to different people. But are you able to give us an approximation of how many masturbation conduct reports you would have seen in Wix on, 21, 22, 23? If you can't, you can certainly tell us that.
Yeah, I can't.
Okay.
I can't tell you that because
That's okay. Okay.
Right.
Well, earlier you said it happens all the time. I'm wondering what information did you use to make a comment about masturbation happening all the time?
Because when I say all the time, because it's an ongoing violation. I mean, whether it's not like 200 people did it in one day, it's an ongoing issue in all institutions.
So if you know it's an ongoing issue, wouldn't you think there would be a lot of conduct reports in the system about that violation?
Objection, speculation.
Sustained. And let me
Do
tell you
you
why I
know-
sustained the objection, because she's already said she doesn't know the number. I tried to get her to provide us with a range or an approximation. So anything more, she said what she said, is not really going to be helpful because the witness has already said she doesn't know. Please continue.
This is around conduct reports. And if a warden is aware that there are a lot of happening all the time, people masturbating, I would expect, because in the 303, it says that's a major offense, why there wouldn't be any corresponding conduct reports in the system.
Are you asking the witness that?
No, I'll move on. Do you know what a 980 is?
Objection, relevance.
Well, I don't know what a 980 is, so I guess I can't I can't make a determination of whether or not it's relevant. Can somebody tell me what a 980 is? First of all, and attorneys, let's just ask the witness, and she can tell me what it is, if she knows what it is, and then the follow-up question, you can make your objection, and I can make a ruling. So first of all, Ms. Eplet, do you know what a 980 is?
Are we talking about like the sex offender laws?
Yes.
Okay.
So, and what is, to your understanding, what is a 980?
My recollection is a 980 is somebody who is civilly committed after their correctional sentence to DHS. Their offense also meets the 980 statute, and then from there, that's what I believe prompts the transfer to Sand Ridge is where I left off in DHS, where they're committed in DHS.
And if an
Go ahead.
I'm sorry.
No,
If
go
an
ahead.
If an inmate has a 980 coding, would there be any sexual restrictions or you know, specific mandates that inmate cannot violate related to their sexual conduct?
Objection assumes facts, not an evidence.
Well, I don't know that. I think she's asking a hypothetical because she's not tying it to a particular
Well, we'll go ahead and just
situation.
put it into Ms. Ostrowski. Do you know if the inmate that Ms. Ostrowski wrote a conduct report on for masturbation was classified as a 980 sex offender?
I have no idea.
Did you ever investigate that?
No,
Object.
sorry.
If people are, if wardens, deputy wardens, the security director was investigating a conduct report of an inmate that had a 980, would they have to make special considerations regarding that designation?
Objection vague.
That objection is overruled. You can answer the question if you know, and if you know and understand the question, please answer it.
So if I'm understanding the question correctly, I don't have any experience with equating dispositions of conduct reports relative to the 980 law. And the reason I don't know of anything, or I don't recall anything that would drive treating a 980 person differently than somebody who doesn't have that law potentially applying to them, unless and even what I was going to say was unless they're in sex offender treatment. But even if they weren't a 980 potential, whether they're in treatment is more relevant than I think the 980, meaning that they may be held to different ramifications or consequences if they're in treatment. And for example, I mean, if they're in treatment and they contacted a minor or had contact, via phone, and they talked to somebody that they shouldn't have, I think the gravity of that would be handled through the conduct, potentially through conduct report, but a lot through the treatment program as well. But to my recollection, I don't know that a potential 980 weighs in to any disciplinary process, especially because when they're still in the prison system, those that could potentially be held over for 980, that hasn't been a determination yet. And it's determined, I believe, later in their sentence. So whether or not they're going to be committed, I should say. So I don't know of a time when that in and of itself weighted a heavier disposition.
Okay, I was just trying to get a sense of what the purpose of the designation was if it didn't impact anything. But thank you. Do you know, or have you worked with a colleague named Rex Smith?
No, I never worked with him.
Okay, and do you know who he is?
I do. He was when I became familiar with who he is, he was a supervisor at WRC.
Okay, and how did you work, in what capacity was your relationship?
We didn't really have one. I never worked with him.
Okay, all right. Did you? Okay, you said you worked with Jim Zanin.
Correct.
Did you ever discuss the X building with Jim Zanin?
Frequently.
Were you on the mortality review board? Building review committee, whatever it's called?
Yep. So the Committee on Inmate and Youth Death, yes, I was.
So what is the purpose of that committee?
The purpose of the Committee on Inmate and Youth Death, that is an independent committee that I want to say the department sponsors, but it really is, it's independent. And when there's a death at an institution, the institution holds a mortality review with the local site where the inmate died. Sometimes it's in conjunction with another facility. If they were at, let's say, Oshkosh and they transferred to the DCI infirmary, then we would do a joint mortality review. And that review then goes to the committee that I also sat on, the Committee of Inmate Youth Death. And that was a committee that had an independent physician from the community in Madison. We had a forensic pathologist from UW. We had a retired firefighter, a nurse, myself. There's a warden always sits. So I sat for, I think it was 2 years. Let's see. Yeah, I mean, I'm pretty sure I remarked on everyone that sits on that committee. But it's physicians, nurses, a warden, a pathologist. And what we did during that committee was we took everything from the local mortality review, and we reviewed it and looked at recommendations. And then we weren't a decision-making body at all. We simply made recommendations based on our own independent review.
Did you ever talk about officer or sergeant misconduct during the mortality review board?
I'm gonna object as to relevance.
Sustained.
You discussed the X building inmate death at that committee, correct?
Correct.
Objection, relevance.
Sustained. We're not going to get into mortality issues. We're here to talk about terms or conditions. Let me finish, please. Terms or conditions of employment with respect to deletion of conduct reports. We're not going to get into whether or not there was general misconduct, whether that resulted in inmate deaths, whether or not there's mortality reviews. We're just not going to get into it. So please move on to your next topic.
Did any of the officers, the male officers that worked with the inmate that was deceased, get disciplined?
Objection, relevance.
Relevance.
Male discipline versus female discipline.
We're dealing with
an inmate died.
We're dealing with a very narrow issue. The issue is whether or not there was different treatment with respect to deletion of conduct reports. Again, we are not going to get into mortality reviews, misconduct that's not related to deletion of conduct reports.
And retaliation for filing a complaint.
Again, the retaliation for filing the complaint relates to the initiation of a disciplinary proceeding. So
that's what I'm talking about right now.
No, we're not going to get into that. Move on to your next topic, please.
Well, I'd like to note that this is a direct comparator to Ms. Ostrowski in terms of disproportionate discipline for a female officer, pretextual, versus an actual discipline action that was never taken against two male officers.
When you're looking, just so the record's clear, when you're looking at whether or not somebody's a comparator with respect to disciplinary action, you look at the nature of the offense. The offenses are not similar. What Ms. Ostrowski was disciplined for, or the initiation of the discipline process related to her disclosing information relating, which arguably, and I don't know, I've made a determination, was personal identifying information. So they are not even remotely similar. So please move
Because
on.
they didn't get disciplined.
You have to look at, again, and I'm going to leave it at this, Ms. Keither, you have to look at what the nature of the offense is. You don't look at whether or not they were disciplined. You look at whether or not the offense is similar, and then it is relevant.
There are many factors to look at in comparator data. I have studied the federal government's comparator figures. They are not just apples to apples on every single point. What we are discussing here is the lack of discipline for a serious event, the death of an inmate, and the lack of discipline that 2 male officers had for noted misbehavior and failure in duty versus what a female sergeant got as discipline for capturing the date of birth of an inmate in her ERD complaint. Okay. So, was Jim Zanin on that committee?
Objection relevance.
Relevance. I'm going to instruct you one more time, Ms. Keither, then we'll take a break to allow you to compose yourself and listen to and comply with my directive. We are not going to get into that committee. We're not going to get into maritality issues. If you continue, if you ask another question, we'll take a break and I will allow you to decide if you're going to comply with my instruction. Do you need that break, Ms. Keither? I've ruled on your objection. You've made your record. I understand you don't agree with my objection or my ruling. That's not at all unusual. But what is not acceptable is after I've made, please let me finish. What did you just say, Ms. Keither?
All the commentary? It seems like
all right,
my commentary.
We're going to take a
break. Sure.
We're going to take a break. And if you come back, there is a case that I will cite. If you come back and you refuse to follow my directives, I will give you another warning. And at that time, I will potentially make some decisions about where and what you can continue with in the case. So I hope when you come back from the break, you're able to move on to a new area and not continue to argue. Again, you've made your record. I understand your objection. I've ruled on the objection. It's not appropriate after I've ruled on objection to continue to argue with me. Everyone come back
I'm
at
making
10:20.
I'm making an argument. That's what we're supposed to do here. This is an adversary setting. So I'm making a legal argument. I have a right to do that. So the fact that you're taking my legal arguments as a personal attack is concerning. But thank you. We'll go on a break and we'll come back.
No, we will. Now I will address what you just said. I'm not taking it as a personal attack. What I am saying is once an objection has been made, once you've had an opportunity to say what you're going to say, and I issue my ruling, I expect you to move on, not to reassert and re-argue the objection. You've made your record. So
once she objects and she makes and I can make an offer to address what the issue is, and that is how it goes. It's a game back and forth. The record has to be complete, and if I have a rebuttal to her objection, I have a right to make it. And you shouldn't take it personally.
Ms. Keither, you can continue to say I'm taking it personally. What I am trying to do is move the hearing ahead in an efficient manner in the way it should move ahead. And it is not appropriate after an objection has been made, argument has been given, and it's been ruled on for you to continue to argue about it. And if that does continue, then we will have to deal with it at that time. I think we will take our break until 10:20. We will come back. I am hopeful, Ms. Keither, that you will move on to your next area. So we are off the record.
We're ready
Okay.
whenever. Okay.
We are back on the record. Before you proceed, you did mention offer of proof. I will allow you to make an offer of proof if you want as to why questions about mortality rates and discipline are relevant to this case. If you haven't already stated your offer of proof, please do so.
Thank you. Our offer of proof is the connection that female correction officers are held to a different standard. When they make conduct reports, they are seen as lying or making a fuss about something, and they are then put in dangerous situations with inmates, and they are also disproportionately disciplined. On the other hand, we have a severe instance of an inmate who lost his life in the care of officers, and the protocol that is documented in the record was a violation, and the male officers received no discipline. So thank you.
What was the name of the male officer?
The male officers that were there, I'm trying to. They did not cut the dead
It's
body
okay
down
if you,
for several hours.
if it's okay if you don't have the name. What was the year?
August 8th, it's on my,
August 8th, it's in her investigation,
August 8th of what year?
22.
Who made the decision about discipline?
Well, there was no discipline for the male officers. No investigation. Miss Epplett made the discipline against Miss Ostrowski, but the male officers didn't get any discipline. There was none.
Who made the decision that they weren't going to get discipline?
The Mortality Review Committee.
All right, well,
It's-
okay. So a different body, the Mortality Review Committee made, so what I'm asking you is, were the
Well,
decision
this is
makers?
now we're, okay.
Ms. Keither, I'm allowing you to make the record for purposes of review. I'm not sure, if you don't want to make it, that's fine. Have you gotten everything you wanted to get in?
No, we should follow that's what I was trying to do before I was abruptly scolded and told to go on timeout. So
Are you saying that the decision makers on the Mortality Review Board are the same ones who made the decision about the discipline of Ms. Ostrowski?
Epplett was the warden. She was the warden representative for these two instances. She was adding to the decision-making process, and she is the appointing authority on the end. Remember, everybody else was independent. She was the one who went back to the work environment and had to execute any discipline.
All right. So did you want to say something, Attorney Zacard, before I tie this up?
Yes, I just wanted to point out that the date of this complaint was filed on March 8th of 2023,
3.
sorry.
I think that's correct. It is a 23 date. So let me just tell you what so the complainant has made an offer of proof. So that is in the record. The reason I don't believe it is relevant is what we're talking about is whether or not there are similarly situated employees and a comparison whether or not they're appropriate comparators. Typically, let me give you the easiest example would be if two people were in the institution and engaged in approximately the same conduct and one received one type of adverse action and one didn't. That would certainly be relevant. Generally, for them to be similarly situated, you need to have the same type of offense, the same decision maker, and the same time period. For those reasons, I find that it is not relevant and we have completed our record. So go ahead, Ms. Keither.
Thank you. Although it was the same decision maker, so I'm not sure about that. And she stated earlier that masturbation conduct reports, there are really not a lot of comparators because most males don't report it. So that's why you have them masturbating all the time. So we're going to go to C9.
Okay.
I do have one more question. Miss Eplet, did the mortality review team agree to investigate the male officers involved in the X building death?
The mortality review, that's separate from whether or not we decide or don't decide to investigate or disciplinary process, go down that road. The mortality review is, it encompasses everything, and the institution documents any follow-up, any, recommendations, any changes that we made in relevant to the situation. But the mortality review, that process doesn't necessarily, I mean, I guess it could prompt it, but by the time you get to mortality review, your institution has already done pretty much what they've needed to do. And the Committee on Inmate Youth Death has nothing to do with prompting investigation or discipline. Now, they could make that recommendation, but typically they don't have anything to do with the internal launching of an investigation.
Beyond possibly recommending it after it's been independently reviewed.
That's correct. That could be a decision that comes out of it.
Well, do you know if there ever was an investigation by anybody on the X building?
Objection relevance.
Sustained.
That would be you, Miss Eplet, because you
The
were.
objection was sustained. We've already dealt with an offer of proof on this issue. I made my ruling. You've made your offer of proof. We have the record. Now move on to the next topic. I have C9 up. Would you like me to share C9?
Yep.
C9 is already in the record, I believe, in its entirety. So go ahead. C9 should be up momentarily. Where would you like the witness to look?
Miss Eplet, can you just take a quick glance over this document and see if you recollect this document?
And it is one page. So just to be clear, she's just asking to look at the one page. There's not anything more to it.
Let me know when you're done looking at it, just to see if you're familiar with this.
Okay. Okay.
Okay, do you recognize this document?
Yeah, I do. I do. I mean, yes. And I believe this is, yes, I believe I'm familiar with this.
Do you recall if you had any role in executing any investigation or follow-up action as a result of this conduct report?
I don't think that I had any firsthand dealing with it. I think it was after the fact.
Okay, and when you receive a conduct report, what type of investigation do you do on the allegations that are written in the report?
As warden, I rarely saw conduct reports. I rarely had anything to do with conduct reports or touched conduct reports. Those were, those were dealt with by the security supervisors, the security director, and primarily the deputy warden. When I was made aware of a conduct report, it was usually because somebody was, there was a complaint about something, but I rarely touched conduct reports.
What do you mean there was a complaint about something, about a conduct? Isn't a conduct report reporting inmate violations? But okay, and so what do you mean a complaint? You heard about it when there was a complaint about the conduct report. Can you please explain that a little bit more?
Sure. I mean, and I think in this instance, it was, when this happened, I believe it was, I don't remember who brought it to me first, but when I say there's a complaint, it's the officer or the sergeant, who is, you know, questioning or challenging the disposition. And
Okay.
I can't remember who brought this forward, how I was made aware that this was an issue. I don't know if it was Sergeant Ostrowski or she brought that to others who then brought it to me. I honestly don't remember.
So do you know who does the investigation of what's written here to determine the accuracy?
Objection, facts not in evidence.
Overruled.
Can you repeat your question? I'm sorry.
Sure. I was asking who does the investigation to confirm the accuracy of what is written in a conduct report?
Well, beyond the conduct report, I don't know that anybody investigates it, but during the hearing, that's when the hearing officer hears it. I mean, a supervisor could question it when it comes through initially, if there's spelling or something doesn't make sense. But normally, it, you know, the merits of the conduct report during the hearing, I believe that's when that's dealt with.
So when you got involved, as you said earlier, when there was a complaint, possibly disagreement about the disposition, how would you know how to resolve the complaint? What would you do?
Objection, lack of foundation.
Well, the objection is overruled. I assume the witness, not assume, the witness is going to know what, if anything, she did to resolve the complaint. So the answer could be she didn't do anything. The answer could be she did something. So I think she certainly has the foundation. Ms. Epplett, answer the question, please.
What I would do, after the fact is that I would just ask that somebody explain what was the thought process behind what they determined.
And
But
when
that's
you say,
usually-
oh, you can finish if you need to.
I was just going to say that was typically the extent of it.
So when you say somebody explain, who would be explaining it?
It could be the supervisor who processed it or the person, the hearing officer. How did you reach the conclusion? What was your thought process? If there was something more, could have been a discussion with the security director or a deputy warden. But I honestly can't recall a time that even when there was, afterthought or discussion about a conduct report and the outcome and the disposition, I don't ever remember doing modifications with it. I could be wrong, but I did modifications and I did unilateral reviews with conduct reports. But typically, if there was just a disagreement about the outcome, unless there was something that was so off the rails, it would stand. And I couldn't even cite to you what, if I say something so off the rails, I couldn't even give you an example.
So would it be fair to say that most of the time, what was written in the conduct report, the allegations that were written in the conduct report was taken for truth?
I would say when conduct reports are written, they're taken, yes, as face value. This is what the sergeant or the officer observed.
And do they ever go talk to the officers that author these and say, show me how this really happened?
I can't say for sure, but that certainly is plausible. That certainly could happen. I mean,
Did you ever, in
go
your
ahead.
review, as a person who's making a decision about a complaint with a conduct report. Did you ever go talk to an author of a conduct report to get their side of the story?
Typically not.
And that would include, did you ever talk to Cindy Ostrowski about her conduct reports?
I don't believe so.
Can you bring up C51? Sorry, C41.
I can.
We'd like to offer this.
C9's already been received.
Okay, thank you.
It's missing page 2. I believe that was part of the record made last time.
And you, do you have page 2? Yeah, okay, then there is a page 2. We'll have to get that as mentioned.
And then you said, did you say 51? Is that what you want?
I said 41. I mistakenly said 51, but I changed it to 41.
All right. Nope, that's not what I want. 41. Hold on. And it appears 41 is a one-page document. I don't see where we, hold on a second. And 41 is in the second email is in. So everyone's on the same page. The email from LeBron to a number of people. I don't believe the first portion of C41 is not in because we didn't have a witness to testify about it. We do have this witness who's on the email. So I just wanted to lay that background. So C41 is up. And then when you're finished, Ms. Keither, at some point, you probably want to say I'd suggest if you want the first email in, just offer that. So go ahead.
Okay, thank you. Ms. Eplett, can you take a quick look at this email and just familiarize yourself with the content? And when you're finished reviewing it, you can just let us know and we'll ask a couple questions.
Okay.
Okay, are you familiar? Do you remember this email?
I do. Yep.
And was this email a representation of some of the investigation that you do when you have a complaint about a conduct report?
Objection, there hasn't been any foundation about this.
Ms. Eplett, did you send this email?
Yep. It looks like I did to Stephanie Hovey. And it looks like it was some kind of follow-up that someone had asked me for.
Well, who would have asked you for this follow-up?
The fact that I sent it to Stephanie, she may have reached out, she may have been the one that reached out to me. It could have, I don't know, who would have reached out. I can't say for sure, but the reason that I'm saying that is because it's titled follow-up, information follow-up. So it could have been, I don't know if Sergeant Ostrowski reached out to somebody else, from Kevin Carr to Sarah Cooper to Stephanie Hovey, and they wanted me to follow up to see what was going on.
Can you remind me who Stephanie Hovey is?
She was the assistant administrator at the time, and she oversaw Oshkosh.
Okay. And so in your email to Stephanie, did you feel that, how did you conduct this investigation to come up with your report here to Stephanie Hovey?
Honestly, I really don't recall. I could say generally speaking, I had conversations with people, and the email from LeBron, Lieutenant LeBron was sent to me in July. Um, and so from the fact that it was sent to me in July of 22, and then in November of 22, I was following up. I couldn't tell you what happened in between those months. I honestly don't recall.
And do you recall if this email string is in reference to the masturbation conduct report? That's referenced throughout.
Um, oh, I'm sorry, my computer went to low battery. Sorry.
It's okay.
In conversations before that about.
So, okay, you asked me if this was in reference to the masturbation conduct report.
Yes.
Um, but I don't know because this references not wearing an ID.
Okay, so you don't know.
When I read this, I would read this as this was the conduct report that was up on the screen before regarding the inmate that had got a conduct report dismissed for not having his ID on and arguing about not wearing his ID.
And,
That would,
and it could be that one, and you may have investigated that one. And you
yeah,
were
I may
giving-
have looked into that.
And let's just be
You-
clear, when you say that one, which one are we referring to?
I thought she was referring to the ID.
Okay, that's what I thought too, but we need
Mhm.
to be clear because that one does
Right.
not identify specifically. So when you testified that one, Ms. Eplet, you were referring to the ID, the inmate with the ID conduct report, correct?
Correct.
Okay, thank you. Please go ahead,
But
Ms. Keither.
you are saying that you don't know if this string was about that ID issue or if it was about the masturbation conduct report. Are you saying you don't know which one, or it could be either?
Well, by the content of the July 28th, 22, um, by that content, that makes me feel as though we're talking about the conduct report for the inmate not wearing his ID.
And do you know if Captain Christensen directed Miss Ostrowski to write a conduct report for the masturbation incident?
Oh, I don't know.
Do you know the date of the masturbation conduct report?
Not offhand, no.
But you know the date of the ID one?
No, other than you show that was C9, I think, right?
Well, C41, the email that we're
Oh.
looking at. I'm trying to figure out why you're thinking this is about an ID badge.
The only reason I'm getting that is because in the body where Lieutenant LeBron sends it to Zanin, Captain Booker, myself, and Emil Tony, he talks about a conduct report being dismissed and that I did not see him disobey orders by not wearing his ID. So that's where I'm assuming this is regarding the inmate who wasn't wearing his ID and the conduct report got dismissed.
Are these emails connected or were they just placed on the same page? That's
No,
what I
they're-
don't, that's what I need to know.
Okay, well, we're gonna bring up C7.
So, but let me ask Ms. Eplet, do you know, are these two emails related or to your knowledge, are they just placed on C41 together? I'm trying to track if it's part of the same thread. It does not appear to me there's a time difference, a substantial time difference. One's July, one's November. And it doesn't appear to me, usually in a thread, you'll see, I don't see that either. And if nobody can answer, that's fine. It's just a question I have. Are you able to answer that question, Ms. Eplet?
I can't tell you if this is
Okay.
all connected, the ID, the masturbation conduct report. It feels separate, but I can't say for sure.
Okay, then, Ms. Keither, you wanted me to go you still want me to go to C9?
Well, I guess do you see in the, in C41, the second line of your email, it says, the incident she's talking about below original email. You still may not be able to say if that's the email, but could that have been the email that was the discussion was about, where it says below original email?
So it feels like when I'm responding in November of 22, what I'm referencing is the below email from July 28 of 2022.
Okay. And so, did you ever investigate, where Victor LeBron says Sergeant Ostrowski has threatened me?
No, I never investigated that.
Do you know anything about it?
I remember at the time, when this was brought to me, I remember having discussion about it. But I don't recall, anybody investigating. Lieutenant LeBron said he felt like he was being threatened. I don't believe anybody investigated that.
Okay. So there wasn't anybody concerned that he felt threatened?
Objection relevance?
Sustained.
Okay.
Do you want to
Um,
offer the first portion of Exhibit C41, which let me just identify it for the record? Again, previously C41, the email from LeBron to a number of people was received into evidence. The first portion, the email from Eplet to Hovey, if I'm pronouncing that correct, was not. Do you want to offer the first portion of C41?
yes.
Any objection, Attorney Zacard?
No.
The first portion of Exhibit C41 is received, which means Exhibit C41 is received in its entirety at this time.
Okay, thank you. Okay, can you, we'll go to, C3, please.
Okay, and give me 1 second. C3 does appear to be in already. Let me get to C3. Okay, we are on C3. Go ahead. And let me just
Okay.
ask, did anyone bring up that we were missing a page of C3? I don't see that in my notes, but I just want to make sure because there has been discussion about whether or not these reports have more than one page. Go ahead, Attorney Zacard.
It says page 1 and 2 at the bottom.
Okay, and Ms. Keither, do you know, is there in fact a second page?
We have both pages, so.
All right,
I'm
so
not sure
I'm sorry. It's there. The next page.
which is marked C4.
that's not the next page. She's asking you to go up one just to make sure they didn't get out of order.
Oh, so I
Or no.
messed up. My apologies.
Okay.
So the first page of C3 is actually the second page of C3. Is that right?
Yes.
Okay. And do you want me to start on the second page of C3? Is that where you want to direct the witness first?
Okay. Can you take a look at this conduct report from May 29th of 2021?
Is there any way to make it a little bigger?
Yes. So I did, but I can certainly do a little bit more. So just tell me when you want me to scroll down. Are you, I
That-
think
that's-
that's, okay, you can
that's
see it
better.
now. Great, okay.
Okay,
Okay. And I suppose we'll have you look at this second page right away while it's in the flow here, just so we can see the ending of the document.
And so, Ms. Eplet, when you've completed looking at the top, I think we do need to go to the bottom. So just let me know when you're ready to go to the bottom of the first page of C3.
I did want to make a record before.
All right, while
Proceed
she's
on this.
looking, why don't you go ahead and make your record?
Okay,
Go ahead, Attorney Zacard.
thank you. I see that this is from 2021, which would be outside the 300 days. So I would object to this in terms of it can't be utilized in terms of this cannot be part of the decision for this
Well,
particular matter.
And I understand your objection, so I'll state this and then I'll ask for a response from Ms. Keither. So it is certainly not actionable in the sense that it is not something I can make a decision that this was a discriminatory, anything discriminatory related to this. However, it could be relevant. What is the relevance, Ms. Keither, of this? You would agree that this is outside the statute of limitations?
Well, we have ongoing violations in, they hook to one another, and that was
No.
part of our
The-
arguments.
this
This
is
is
a-
when the decision maker, Miss Eplet, Warden Eplet, during her time frame as the warden, made a decision or was involved in a decision as the appointing authority to take action on this conduct report written by Miss Ostrowski.
Right, it's a discrete employment action, you would agree?
I already made my argument. The ongoing violation is something that happened over a period of time. This is a direct example of the conduct. So I don't know, you make your decision.
Well, I'm trying to, if you don't want to answer my question, that's fine, but you haven't asserted a continuing violation theory. The complaint portion that's alive is discriminating against the complainant in terms or conditions of employment because of sex with regard to deletion of conduct reports that fall within the statute of limitations. So I'm just trying, it may be that there's
This
some
is a
relevance.
deletion of a conduct report,
Well, I
a
understand that.
reprimand.
That doesn't make it relevant. So let me
Now
ask you
we
this.
can't get a conduct report thing in. That's all we hear is it has to be a conduct report, but okay.
Well, I haven't finished my discussion. So Attorney Zacard, my recollection is that this document was received at the prior hearing without objection. I just don't recall why. Here's what I'll do. I will overrule the objection. I will allow Ms. Keither to get into some limited information. Arguably, this is some evidence outside of the statute of limitations that may be relevant to the claims in this case. So go ahead, Ms. Keither.
Okay, so Miss Eplet, do you know who wrote this conduct report?
Sergeant Ostrowski.
Okay, and do you know if this was considered a major or minor offense?
They have minor disposition checked on there. Otherwise, I wouldn't have known just cold, but I can see it
Oh.
on there.
No, I'm sorry, you're on the second page. Can we go back to the first page now? Pardon me. So if we go down to where, Mr. Tony, Security Director Review, what did Mr. Tony mark in these boxes?
Looks like a proceed as a major.
Okay, and what else?
Oh, I'm sorry. Risk of serious disruption in the facility or community.
And that was completed by the Security Director, correct?
Correct.
Okay, then when we go to the second page, and so, I'm sorry, ALJ Reinhardt, can you go to the second page, please? This is where, do you know Nikki Schwebke?
Yep, she was a lieutenant.
Okay, and do you, what did she mark on here as the final disposition?
Reprimand, other dispositions, apologize owed to Sergeant Ostrowski.
And did it remain a major disposition or was it changed?
It appears to have changed to a
Ms.
minor.
Ms. Eplet, do you have any firsthand knowledge of this document?
No, I didn't have anything to do with this
Mi-
conduct report that I recollect.
All right, Ms.
This is the
Keither,
conduct report from the previous email, part of it.
well, you haven't
And it's-
established that, so I think you ought to establish that.
Well, if we look at the dates, which we could do in a brief, but,
I thought the previous email had a 22 date. That it was July of 22 and November of 22.
Mhm.
And this is 21.
okay,
My
So-
point is just this, with respect to the conduct report, if the witness doesn't have any recollection or know anything about it at this time, having her look at the document and having you say, doesn't it say this, isn't helpful to me at all. So,
Well,
and I believe
we-
we already have testimony, I think, on this document from Mr. Tomey, I don't recall. So what else do you want to go over with this witness on this document?
well, I guess the bigger question is, Ms. Eplet, because you said you knew Nikki Schwebke. How did you discuss her decision to alter or to reduce contested disposition of a conduct report? Did you ever just have those discussions with her?
I would object. I don't think that are facts and evidence about if it's contested or not.
Well, I'm
Well,
just
let's-
reading the heading there.
It says uncontested.
And I don't know where you folks are at, so where are you
Well, it
looking?
says record of contested. Okay, so if you go back to the final page of C3, which is the first page here, under record of contested.
Uncontested.
Okay, well, I was looking at where the checkbox was, where it says minor disposition. It's under that heading.
I don't see
so-
anything saying uncontested. So-
The
Uncontested
first,
is the first bar.
A record of uncontested major disposition. Okay.
Right. So they're both, the headings are there, but because it went from a major to a minor, it's under the contested.
I-
Well, regardless, the question I think is, so we don't waste time on this, is whether or not she had any discussion, she being Ms. Eplet, with Nikki Schwebke about this particular document or this matter. That's what you want to know, right?
Yes.
And can you answer that question, Ms. Eplet, please?
No, I rarely, if ever, had anything to do with the hearing officer and due process.
You didn't ever go digging for investigations?
objection relevance.
It's a complete
I'll allow it, although
contradiction to
I think this has been covered and it's cumulative, but go ahead. I think we've covered extensively the issue of what her involvement is, but go ahead. The question was, you didn't ever go digging for investigations. That was the question. Can you answer that question, please, Ms. Eplet?
Yep, I had nothing to do with due process. However, when I say investigation or digging or follow up, whatever word you want to use. Usually it was after the fact of the hearing officer. And then I would ask questions. If somebody brought it to me and brought an argument as to what they were not happy with, or upset about, or whatever the case may be, then I would ask questions about it to try to understand, all the thought process that went into writing the conduct report, the disposition of the conduct report. But I didn't have anything to do with due process. That's not the warden's role. The role that I had primarily with due process was when a conduct report was heard and a disposition was received, then if the inmate challenged that through ICRS, that's when I would engage with conduct reports.
Okay, so what would be the purpose of talking to everybody after the fact when you didn't have any decision-making capabilities?
I'm going to object to the form of the question.
What's your objection to the form of the question?
It's information, not in evidence.
I'm just repeating
No,
what
hold
she
on.
just said.
So what would be the purpose of talking to everybody about the fact when you didn't have any decision-making capabilities? That would be the question. I don't think there's any facts not in evidence. She's asking the witness, if she has an answer, what was her purpose? I will just tell you, she's already testified. If somebody had a complaint, I'd look into it. And the purpose was somebody brought a complaint to her attention. Ms. Epplett, go ahead and answer the question, which is, what was your purpose of talking to anybody when you didn't have any decision-making capabilities?
If the decision was already made and it reached my desk by employee, whatever that employee was, it would be reasonable to ask questions of people as to, okay, this person, maybe they're upset about this, and how did you reach this conclusion, and what's the background, so that I, could gain an understanding of thought process.
Okay, very good. Can you bring up C30, please? And we said this one was already admitted as well, previously?
Yes, the C3 was admitted. You said C30.
Yes, C30, please.
I don't see C30 has been referenced at all. So C30 appears to be a one-page document. Go ahead.
Okay, once again, Ms. Epplett, if you could just take a moment to familiarize yourself with this email.
Ms. Keither, would you agree that the highlighted portion was not on the original document, and that's something that you added, or is that something that was on the original document?
No.
Our understanding is that Ms. Epplett highlighted that.
All right.
And we can prove that on the basis of the content of her email, where she writes, the highlighted is what I would like to discuss.
Thank you. Got it. Would you agree, Attorney Zacard, that was highlighted on the original?
I mean, I can't remember anymore.
All right. Well, why don't you do this, Ms. Keither? Perhaps that's one question you can ask her based upon the content, just to confirm. I think it's important we all know whether or not that was added after the fact or that was in it. Ms. Epplett, have you had a chance to review? And I want to make sure I went down to the bottom. I think you have the entire document up in front of you. Have you had a chance to review the entirety of Exhibit C30?
Yep, to the highlighted. Yep.
Okay, go ahead, Ms. Keither.
Okay, so let's start with the bottom email. Who is that email from?
It looks like it's from Sergeant Ostrowski to Sarah Cooper, Miller, and Carr.
Okay, and so it wasn't to you, correct?
Correct.
How did you get this email?
Honestly, I don't know. It could have been forwarded by any one of those three people, meaning Cooper, Miller, or Carr, back to me to say, you know, this was sent to us, be aware of it, or this was sent to us, let us know what's going on. I can't say for sure who sent it to me.
Okay, and then when you saw this email, who did you send it to?
Well, it looks as though I sent it to Zanin and Tracy Fink.
And can you remind me who Tracy Fink is?
She was our HR director.
And so why did you highlight and you said you wanted to discuss it with those individuals? Why did you highlight that bottom portion?
Because that's concerning.
Okay, what's concerning about it?
If we have a unit manager that is speaking to an officer about the security director mistreating management staff, it's concerning because from my perspective, that conversation should not have taken place from a supervisor to an officer. And so that was my one concern on that end. The other concern is if Ms. Sabel felt that the security director was mistreating management staff, I wanted to be able to talk to her about that.
Were you Mr. Tony's supervisor?
No, the deputy warden is.
Okay. So what discussion did you have with James Zanin and Tracy Fink regarding that statement?
The details I can't remember. I imagine that it was exactly what I just said was we either, there could be an issue with the unit manager, if she was upset with the security director, or mistreating management staff, that isn't something that you should be discussing with an officer. And again, the flip side of it is if she really felt that there was mistreatment of management staff, then that's something that she needed to bring to us, so that we could have that conversation. But I don't recall what the discussion was, and I do not recall what the follow-up was with Ms. Sabel.
Did you do any investigation?
Objection,
think-
irrelevance.
What is the relevance?
Well, the relevance is the whole section on the top here is about the dismissed conduct reports. You didn't spend any time addressing those matters, which are directly impacting Ms. Ostrowski's work environment, its safety, and her being exposed to all kinds of sexual activity. You didn't investigate any of those, but you wanted to come down here and put your time and investigatory business on somebody you didn't supervise and somebody that has power over Miss Ostrowski.
Well, I think the relevant question is why did you investigate what's highlighted and not the prior paragraph?
Exactly.
And that's the question.
So the only thing I can say to that is, I may not have focused on the first part of it because that may have been something that we previously had already talked about. And the highlighted part of that may have been something that I was not aware of.
But you're just guessing, right?
Let her finish her answer, please. Have you finished your answer?
I have.
Okay, and then the question I think is you're just guessing. And can you answer that question?
To a certain extent, yeah, I can't say sequentially fact by fact exactly. So there is on my part, there is some guessing and just speculation.
Well, I don't need you to do it fact by fact. You can speak about it generally, but the question was, what did you do to investigate Miss Ostrowski's, as the warden of that facility? What did you do to investigate the substance of what Miss Ostrowski reported, not to you, but these other individuals?
I with
Can
yeah,
object. It, what does it, objection relevance?
What is
And
your job duty? Were you
and
supposed to be
hold on.
investigating?
There's an objection made before you speak. I will overrule the objection. I think it's probably of limited relevance, but I think it's appropriate to answer the question. I suspect Ms. Eplett's saying, I just don't know. I don't recall, which is an entirely acceptable answer. If you don't recall, we don't want you to speculate. We don't want you to guess. Do you know if you did anything in response to the first paragraph of the email from Ms. Ostrowski to Ms. Cooper and Mr. Miller and some other folks? Do you know if you did anything?
I believe we had conversation about it. There was no formal investigation. The second part that's highlighted, I do not recall how that was addressed or what the outcome was. But I also want to say that beyond an investigation, there were multiple, I believe, if not one, more than one, when Robert Miller was involved, that was through the intake process. So I believe Sergeant Ostrowski did one, if not two, formal intakes on harassment.
So you said we discussed. Who is we?
Well, I mean, we could be myself, the deputy warden, the security director, HR, or it could have been myself with whoever, it could have been an individual, it could have been the executive team. It could have been multiple people when I say we. It just would be dependent on the situation or circumstances, whoever was involved.
Well, but we were talking about this circumstance. I asked you about this particular event, and you said
Mhm.
we discussed it. I'm just asking you who we is.
For this one, I believe this would have been myself, the deputy warden, and the security director.
And so the deputy warden is James Zanin, and the security director was Emil Tony.
Correct.
Are-
I don't remember if I spoke with Lieutenant LeBron directly. I could have,
Are
I
in-
just don't remember.
Are any of those people, I mean, by their job titles, we can tell, but they don't work in HR, do they?
Objection relevance?
Sustained.
Have you ever had any training on investigatory practices?
Yes.
What training have you had?
When you become a supervisor, you get training in how to conduct investigations, and then periodically throughout the years as a supervisor, you go through update training.
Okay, and so as a warden from 2021 to 2023, would you say you had more than one training? Or give us a range on how much training you had?
I would say annually, maybe it formally, maybe once a year, we would have updates. And then there was, informal discussions depending upon, if we were at a warden's meeting or if we were meeting with HR or personnel over issues. It was, we would get updates from our ER specialist and from personnel regarding, this is going to be a change in how we do business. So it would be informal update kinds of things. But I would say generally on an annual basis, we would get a formal update training.
So when you had this formal training, did you, and you were executing the practices that you learned, did you learn about documentation?
Objection relevance.
Sustained.
Did you ever document any of the investigations you did?
Objection vague.
The
Can you,
3-year period. During 2021 to 2023, when you were the warden at Oshkosh, did you ever document in writing the investigative process or ever? And then we can answer it for Cindy Ostrowski.
So I never did any formal investigations as warden. Most of everything that I did was informal.
Is that what they taught you in the training?
I'm gonna object, that's argumentative and lack of foundation.
overruled, you can briefly answer the question.
Wardens have the discretion to look into, anything informally that we want to, and investigators, if we're doing a fact finding, kind of before we even launch an investigation, that is considered to be informal as formal informal. But again, as a warden, I wasn't the person doing the investigations. I was the person who would either support an formal investigation, or informally we would handle something.
Let me ask a question. The word investigation has been bantered about. And it occurs to me there is a difference between, it seems to me that the investigation, when we talk about an investigation, that's a formal process at the Department of Corrections. Is that your understanding, Ms. Epplett, that when you talk about investigation, you're talking about a formal process under your rules and regulations?
Yes.
And when you talk about an informal investigation, I'm just trying to get a sense. It sounds like you've said informal investigation, but it's really not. It's you looking into something as opposed to you following a formal process as outlined by the DOC rules and regulations about how to investigate something. Is that correct?
Yeah, I mean, there's a fact finding that is simply gathering information. But again, the informal piece of it is a warden, any supervisor, just, informally, asking questions to gain a better understanding or to process something to make sure that, we're all on the same page with the direction that we're going. But it doesn't necessarily have to be, on a formal investigation packet. We look into things all the time, and have discussion about it. It doesn't mean that it's necessarily a formal investigation.
Right, go ahead, Ms. Keither. I
So
interrupted you.
do your contributions, your informal contributions, ever make it to the formal investigation packet?
Objection vague.
Overruled.
I'm not sure I understand the question.
Well, I don't know how to simplify it any further. You said that your role was mostly to do informal investigations. Those are phone calls with people, digging and chit-chatting, conversation that may not have a record, but then you might complete a form or you might provide information by email to one of the individuals who is doing a formal investigation, and then that information is used, correct?
Objection, that's compound.
It is compound. I think it misstates her testimony, but you understand. Why don't you answer? The question really is whether or not your informal we'll call it investigation, but your follow-up conversations ever make their way into, for instance, findings of fact in a formal investigation? I think that's the question.
I couldn't say yes in this instance, but it certainly is possible. And the reason that I say that is, if I'm reviewing a formal investigation, a 15807, the packet that is our disciplinary packet, and if I'm reading it and I say, this doesn't make sense, follow up with this or ask this question, so yes, that input does prompt further investigation, further investigator, investigation.
Okay, so are you a fact finder?
Typically wardens are not fact finders, but we could be, just on the notion that we can ask questions about anything really. But typically what I would do is I would assign it to a supervisor to do a fact finding or to do the investigation. But I myself typically did not do that. In fact, there was probably no instances of me doing an actual fact finding as a warden.
Who was the fact finder on Miss Ostrowski's case?
Whoever the investigators were.
Which case are we talking about? Are we talking about what was done with respect to this email from Mrs. Ostrowski? Is that what you're asking her? Because I haven't heard that any investigation was done at this point. So
Well, that's my understanding as well, but,
if there's not an investigation, there's not going to be a fact finder, right? Let's just ask her.
well,
Let's just say, Ms. Epplett, to your knowledge, was any investigation conducted, a formal investigation with respect to Ms. Ostrowski's email of July 19th, 2022, which is Exhibit
Beyond
C30?
I don't know. I don't recall any investigation.
All right. Next question, Ms. Keither. I think
Okay,
we've
so-
exhausted this line of questioning.
right.
So do you want to offer Exhibit C30?
Yes, we'd like to offer.
Any
Exhibit
objection to
C30.
Exhibit C30?
No,
C30 is received.
Okay, Miss Epplett, we're almost finished here. You mentioned Robert Miller as being an individual that you had discussions with. Is that accurate?
Yes, because I believe Robert Miller was one of the persons that conducted intake with Sergeant Ostrowski.
Okay. And do you know if Robert Miller, I mean, obviously they worked together. I was just going to ask you if they worked together, and you said they worked intake. So they did work together, right?
Who worked together?
Robert
Miller
Miller and
and Ostrowski.
Ostrowski.
Oh, I'm sorry. Yeah, I wouldn't have said that they worked together, but Robert Miller conducted the intake.
Okay, what is the intake?
That's when somebody has a harassment complaint, bullying, hostile work environment complaint, they can do an intake. And that intake is basically the employee choosing the supervisor that they want. And there is an outline for the supervisor to follow, but really the upshot of it is it's the employee's right to do an intake and map out the who, what, why, where, when of how they think they were bullied, harassed, or somebody creating a toxic work environment for them.
So this is like Mrs. Ostrowski receiving complaints from other employees, correct?
I'm
Like,
sorry, I'm
I'm-
not following.
Okay, I'm not following what the heck intake. So intake, Ostrowski and Miller could intake her, I thought you said harassment, bullying, there were a variety of other hostile work environment. She could receive complaints. Those two individuals could receive complaints from other employees, correct? On those matters?
objection. Form a question.
Overruled. Let me just ask you this. So you said intake. The intake was done. Who was the intake done for? I tend to understand the same thing Ms. Keither understood, that if intake was done, it was with respect to other employees' complaints about Mrs. Ostrowski. Is that your understanding, Ms. Epplett?
No.
Or are you saying, no? Okay, then
Not
I'm
about
sorry.
Miss Ostrowski. Oh, Miss Ostrowski was somebody designated, almost like a representative, right? An employee representative. And she has served as a representative before, but the intake is her receiving complaints from other people about bullying they experience, harassment they experience, hostile work environment. She and Robert Miller would receive those complaints. Is that correct?
So,
If it's not, describe it, please, because none of us
Yeah.
understand what you're talking.
so an intake is the opportunity for a single employee to bring forward their complaint about something that has happened to them, and regarding either harassment or bullying or toxic work environment. Now, when that person can pick whatever supervisor they want to go to, and they tell the supervisor the who, what, why, where, when of what they experienced. Um, and it should be about the individual the individual who requested the intake. It should be about something that they have experienced or something that happened to them. But it isn't unusual during an intake for somebody to say, look, this has happened to me and you should talk to these other people. And if that happens, certainly the person conducting the intake could talk to those other people.
And so, do you know if intake was written? Like, if would somebody be bringing something to the intakers in a written form?
I think that when so some folks they will write it all out. Some folks will just meaning write it all out when I say that the entire complaint, or they will have notes, and the person who is conducting the intake, they write down all of the discussion and dialogue.
Okay. And so you were aware that Robert Miller and the complainant were meeting together on these intakes, correct?
Correct.
And were you aware of an intake complaint by Officer Ian Van Rossum?
Yes, he filed.
Was that supposed to be a confidential complaint?
Objection relevance.
How is this relevant?
Ms. Ostrowski has been targeted because she has assisted other employees in similar complaints, like her own, of harassment, bullying, hostile work environment, retaliation, and this complaint is about that. And it resulted in discipline and termination of employees, employees that, like Ms. Epplett, were not even supposed to be involved because it's a confidential process.
Well, that's not part of this case, however. We're here to
Well,
talk
it's-
about deletion of conduct reports and then the disciplinary investigation. The objection is sustained. We're not going down that road.
Okay. All right, we are finished.
Attorney Zacard, I believe you had indicated previously that you intended, and I may be entirely wrong, but my recollection is you were going to examine Ms. Epplett as part before the complainant rested. Is that correct, or am I incorrect on that?
Yes.
And do you have some sense of how long your examination will last?
I'm going to say, based upon things that need to be clarified and then my own questions, I would say an hour.
All right. So so first of all, let's ask the witness her preference because she is here on her time. So there are two options really, Ms. Epplett. I want to hear your preference, then I'll hear from the parties. The first option is we take a brief recess for 15 or 20. I can't recall what we'll have, if it was a half an hour last time, and then we pick up. The other is we just plow through it, which will probably mean you'd be done around 1 o'clock is my guess. What is your preference, Ms. Epplett?
Honestly, I don't have one. I mean,
Okay.
I'm flexible, whatever works for everybody.
Attorney Zacard, what is your preference?
I don't have one.
Ms. Keither, what is your preference?
We don't have one either, so you can.
Well, there you go.
make
That's
it
so let's do this. Let's take a 5-minute restroom break. Let's come back and let's finish, Miss Eplet. Now, just so everyone's clear, Attorney Zacard will be doing her examination, which is kind of a direct. So the complainant will have an opportunity to ask questions that relate to the questions that are asked by Ms. Zacard. I'm sorry, Attorney Zacard. Attorney Zacard, do you anticipate you'll be using exhibits?
Yes.
And will it be an extensive use of exhibits likely? Talking about 10 or
Possibly.
15. Okay, that's fine. I'll be ready for that. Then I
Okay,
can't
I'm
recall
sorry.
this. No, not a problem at all. I can't recall, Ms. Keither. Is this your last witness?
Yes, this is our last witness.
Oh, and then I can't recall, Attorney Zacard, did you have any other witnesses other than Ms. Eplet?
I do not.
You know
So
what?
she,
I'm
Go ahead.
sorry, ALJ Reinhardt, I have to back up because I think I don't, and perhaps I'm getting, did you start testifying in this case?
oh,
the
I
beginning?
am totally sorry. So you do have another witness. And she did. So what I can tell you is there was maybe 10 or 15 minutes of Ms. Ostrowski testifying before we went to the next witness. So what we'll do, thank you for clarifying. I kind of missed that part. So what we'll do is we'll finish with Ms. Eplet. Hopefully that'll be 12:30 to 1 o'clock. We'll take, and I can't recall, Attorney Zacard, did you request last hearing a 30 minutes? Was that your request or am I mixing up hearings?
I don't remember anymore. Sorry.
All right, well, I'd like to take 20 minutes. Is 20 minutes satisfactory to Ms. Keither, Ms. Ostrowski, and Attorney Zacard?
Yes.
Yes.
Okay, so that's what we'll do after we finish Ms. Eplet's testimony. So let's all come back at 11:40 and we'll complete Ms. Eplet's testimony. Then we'll take a break before we finish Ms. Ostrowski's testimony. Hopefully, Ms. Keither, you had started Ms. Ostrowski's testimony. Is your still intention you'll be asking her questions?
I can ask her or, the judge can, I mean, I don't know if.
Yeah, clear.
I would also allow you to ask her questions, but.
Well, I haven't, I usually prepare, but I haven't because to ask questions because you started the examination. So
Okay.
unless you say otherwise, I think it'd be more efficient to do it that way.
Okay.
Attorney Zacard, do you have some sense of how much you might have on cross-examination?
For Ms. Ostrowski.
Yes, yeah. Hour?
It's hard to say. Yeah, probably an hour.
And Ms. Keither, do you think it's doable to be done with Ms. Ostrowski in 2 hours?
Yes, I want to try to go quickly. Yes.
Okay, yeah, I mean, we already have a lot of information, so I just ask both parties
Yeah.
be cognizant of, we don't need to go over things that we went over in detail again. All right, so I will see,
Okay.
I'll shut up. Let's come back at 11:45, I'm sorry, and then we'll take that up. And it sounds like it's very doable to get done today. So I'm going to go
That's
off
the
the record
goal.
and we will come back at, what did I say, 11:40?
45.
45, 11:45. We'll
45,
see everyone
okay.
back at 11:45. Thank you.
Thank you.